I'm Senior Counsel of the ABA Center for Human Rights here in Washington, D.C., and I'm the Director of the ABA International Criminal Court Project. We're very pleased to sponsor this panel today with a very distinguished selection of panelists. I will briefly introduce the ABA Center for Human Rights and the ABA ICC project, and then hand it over to Michael Greco to do additional introductions and some introductory comments. So as some of you may know, the ABA, the American Bar Association, is the world's largest organization, volunteer membership organization of professionals with nearly 400,000 members around the world. And we are the voice of the American legal profession. The ABA has over 3,000 entities within it that cover every conceivable area of law, but one of those is the ABA Center for Human Rights, which is the leading entity within the ABA on domestic and international human rights issues. We strive to work with as many of our colleagues within the ABA to leverage their interest in doing human rights work, but we additionally run our own programs, one of which our programs is the ABA International Criminal Court Project. A bit of background, the ABA for close to 4 decades now has long supported the at one point the theory of and now the actuality of the International Criminal Court. Our House of Delegates have passed numerous policies in support of the International Criminal Court, and the ABA ICC project is the fulfillment of those policies, is putting those policies into practice. Very briefly, the ABA ICC project has a practical and a policy and advocacy education component. The practical part is we work closely with our international partners to help the International Criminal Court in their internal efforts to become more effective and efficient. So that's such as best practices workshops, exchanges of expertise, and the like. On a practical, on the policy and advocacy education, we do advocacy on Capitol Hill in promotion of greater U.S. engagement with the International Criminal Court, and we educate the American legal profession on the court itself. The ICC project, of course, is not just limited to the International Criminal Court, but international criminal justice writ large. And so that's why we're happy today to be sponsoring this Bangladesh International Crimes Tribunal panel discussion. With that, I will briefly introduce Michael Greco, is former president of the ABA. He's chair of the ABA ICC Project Board of Advisors, which is a bipartisan multinational board that advises the ICC project, and he's held many and numerous leadership positions within the ABA. He is a partner at the K.L. Gates law firm in Boston, and with that, I'll turn over to Michael Greco.
Thank you very much, Kip. Can everyone hear me? Yes? I'm delighted to be here, and I'm glad you are here. We are a small group, so that in a way we can have kind of a more personal conversation. And by that I mean that I hope there'll be time at the end of the presentations for questions from you. Let me tell you, first of all, why there's an empty chair at this table. And it has to do with the fact that the Bangladesh government asked the American Bar Association to convene this panel, a neutral forum to discuss the work of the Bangladesh International Crimes Tribunal. The ABA agreed to do that, and we set to work on creating a program that would be balanced with all points of view represented with respect to the work of the court. About 2 weeks ago, the Bangladesh government informed the ABA that they would not be sending a representative to this program. There were 2 who were being considered, and we thought one or both of them might come. We tried very hard to have someone from the government or representing the government's point of view, but to no avail. And so the issue a couple of days ago was, do we cancel the program, or do we move on and hear from the 2 speakers who are here, who I'll introduce in a moment. So that is why we have a slight imbalance, but I know that the speakers and all of us will do the best we can to nonetheless make it a balanced presentation about what the court has done that's positive and what the court has done that needs attention and needs support, needs help. So with that brief introduction, let me tell you what the format of this program will be. We only have until, I understand, 1:45, which means we have an hour and 10 minutes. I believe in making every minute meaningful so that we will move quickly. I will ask, the format is that I will ask questions of the two panelists. I will ask them to be brief in their responses so that we can cover, I have maybe half a dozen questions for them. But I want to get to your questions, so we will move quickly along and hope that we get to that point where you will ask your questions. That's the format. Kip has told you about the American Bar Association commitment to international criminal justice for 4 decades, and in particular, the work that we're doing with the International Criminal Court. And I'm going to circle back to that connection, the ICC and the Bangladesh court, in one of my final questions for the panelists. With that, let me give you some brief introduction of our two distinguished panelists. First, Ambassador Stephen J. Rapp, sitting to my immediate left, is Ambassador at Large, heading the Office of Global Criminal Justice in the U.S. State Department. Ambassador Rapp was appointed by President Obama, confirmed by the Senate, and he assumed his duties on September 8, 2009. Prior to his appointment, Ambassador Rapp served as prosecutor of the Special Court for Sierra Leone, beginning in January 2007. He was responsible for leading the prosecutions of former Liberian President Charles Taylor and other persons alleged to bear the greatest responsibility for the atrocities committed during the Civil War in Sierra Leone. During his tenure in Sierra Leone, his office won the first convictions in history for recruitment and use of child soldiers, for sexual slavery and forced marriage as crimes under the international humanitarian law regime. Toby Cadman, our other panelist to my further left, is a member of the International Criminal Law Bureau, undertaking international legal cases and providing advice, consultancy, and training services to governments, international organizations, and private clients. He specializes in the areas of war crimes, extradition and mutual legal assistance, judicial review, and human rights law. He lectures extensively on international law, criminal procedure, and human rights, and he has provided extensive advice and training to judges, prosecutors, and lawyers throughout the Balkans and Southeast Asia. He has appeared on matters before the International Criminal Court, the International Criminal Tribunal for the former Yugoslavia, the International Crimes Tribunal for Bangladesh, the European Court of Human Rights, and the Bosnia State Court and the UN Human Rights Committee. My first question is addressed to Ambassador Rapp. And I'm going to ask Ambassador Rapp to give us your brief overview of the Bangladesh International Crimes Tribunal. Some of us in the room know that in 1971, atrocities were committed, leading to, in 1973, the adoption of an act of law in Bangladesh, creating the court. But nothing happened between 1973 and 2009, when the government finally took steps to implement the 1973 Act. And it did so in 2010, creating the first tribunal with 3 judges, 7 prosecutors, and others. And since then, there's been another panel created. So the court's only been in operation from 2010 to now. So Ambassador Rapp, with that brief intro, give us your overview, your comments about its creation, its essential characteristics, its important events, and its brief history.
Okay. Well, thank you very much, Michael, and it's a great pleasure to be here today. I think it's important first to note that this is about mass killings and other horrendous crimes that occurred in 1971, and I'm here representing the United States government, and we always make it absolutely clear that we support bringing persons to justice that were responsible for those atrocities, and it's part of the mission of my office. I work with the International Criminal Court, our engagement with it, even though we're not a member, supporting its prosecutions with other international tribunals, but also with national systems. And President Obama's Atrocity Prevention Initiative is founded on the idea that holding people to account for mass atrocities is a core national security interest of the United States, and it's one of the ways that we prevent these horrendous acts of killings. It is important to remember the history here, too, and in that I'd recommend people go to the new book that is out, Gary Bass's book called The Blood Telegram, which has gotten a lot of favorable comment, but describes to a large extent American policy in 1971, which in some respects was unfortunate, the position that the Nixon and Kissinger government took at that time, which opposed liberation of Bangladesh, tilted very much to Pakistan because of the concerns and because it was then secretly providing an entree to China and to Nixon's opening to China that occurred in 1972. But at the same time, Senator Kennedy and others in the United States recognized the horrors that were going on, and our own consul in Dhaka, Arthur Blood, sent back telegrams describing what began in March of 1971, which was the targeting of really thousands of civilians for killing and other atrocities, and crimes that went on throughout that year, in which hundreds of thousands of people were killed. An exact estimate, people can debate that, but there's no question that at least 10 million people were forced into exile into India because of that. And throughout that period, there were killings of people who were Hindu, killings of persons who were secularist, who oppose. Part of the issue, of course, was the fact that the Islamic Republic of Pakistan would be broken up and that there'd be a secular Republic of Bangladesh if a war was won, and so there was that element of the conflict that was truly horrendous. So we very much want to see those that are responsible for this targeted killing of innocents held to account. In 1973, as you say, the government then, under Sheikh Mujib, passed a law that provided for trials, an International Crimes Act. And this becomes important in terms of our later engagement. They also passed an amendment to the Constitution which said that none of the other rights that apply to cases in Bangladesh for serious crimes apply in this International Crimes Act, that it's kind of a standalone, sui generis International Crimes Tribunal. And I think it may have been envisioned initially that some of the persons from Pakistan who were engaged in leading these killings that were then in custody, held as prisoners in Bangladesh, might have been tried. But in the end, they were all sent home as part of an exchange. And so the focus when we came around to 2009 has been exclusively to prosecute those persons who are Bangladeshi, not those that may have been responsible who are now in Pakistan. And of course, we also recognize that in the course of 40 years, a lot of people, certainly some very senior people, will have passed away. We nonetheless, from an American point of view, and I think from a global point of view, believe that it's important to achieve accountability, even if late. Better late than never. And I'll be off next week in Germany, and at one point advocating that they pursue a couple of Nazi cases, people who are men that are 89 years old that were involved in Auschwitz and the death camps. It's important that those cases be prosecuted, even though a long time has passed, because you send the signal that if you commit horrendous atrocities, that there is no escaping it in this life, and that's an important part of the deterrent that we want to create to these worst crimes. In any case, in 2009, as I indicate, the government then, under Sheikh Hasina, went back and looked at the law, made some amendments to it, established an International Crimes Tribunal in 2010, and I was invited to come in by the government to advise them on this, and we can talk about some of that advice to your other questions, but I wrote, after visiting for a week, wrote an extensive letter making some recommendations, not as someone sort of speaking from on high about how they should do it, but looking to their own obligations under the International Covenant on Civil and Political Rights, the treaties that Bangladesh had itself adopted, and some of the provisions that had been adopted in international or ad hoc or hybrid courts, which Bangladesh had supported, looking to bring some of those into effect. But a key part of my recommendations was also that it was very important that this process have a very public strategy, and that as you go about the business of prosecuting a crime in the international sphere of these international crimes, one recognizes you can't prosecute everybody. There are also going to be people that are outside your jurisdiction that you can't get a hold of. There are going to be many people that have died. And so you basically be able to say, this is our strategy, this is our approach, this is why we're pursuing this kind of case and not this kind of case, and to have a kind of an outreach and a dialogue. And one of the things in Sierra Leone we did, where you indicated I was chief prosecutor, there we were to prosecute only those with the greatest responsibility. Myself and my predecessors and other personnel in the court helped set up an outreach program where we traveled the country and answered questions about what we were doing, because in the end we prosecuted 13 people for crimes in which hundreds of thousands of people had been victims and in which thousands of individuals had been potential perpetrators. So it was very important to explain why you were doing what you were doing and why you were selecting these cases. And it would have been very important to have that kind of effort. And frankly, that's one thing that hasn't happened here. And it's given, it led to conclusions that by some that the process isn't fair in terms of who's been selected, that people are selected not based upon the seriousness of their conduct, say in 1971, but on their positions today, for instance. But in any case, we can talk about that later. But the point is that a process was commenced. Toby can talk about the numbers that have been charged. It's still a relatively modest number in the teens of people that have been brought in, and cases that have been pursued in trial. And I'm glad to discuss how that's gone, how my own recommendations were looked at and accepted or rejected, and where we stand today.
Good. Well, that's a good setting of the table, if you will, about the background of the court, when it was created, how it was created, and a little bit about how it's been functioning. My next question is for Toby Cadman. Toby, who has written extensively about the court, not only about the Bangladesh International Crimes Tribunal, but other tribunals. And what I'm going to ask Toby to do for us is to, going against his grain, because I know he's written critically about the court, but I'm going to ask him to limit his answer to this question to what he can say that's positive about the court. Later question, he'll have a chance to speak about what he thinks is not positive and what needs to be done. But so, and beforehand, when I told Toby I was going to ask him that question, he said, "Well, that won't take me very long to answer." But go ahead.
Thank you. And also, I'd like to express my gratitude for being invited and being able to speak about this very important issue, and also express some sorrow that the chair between you and Stephen is actually empty, because one of the biggest challenges that we've faced, and I think Steve and I have sat on at least two previous panel discussions, is that it tends to appear one-sided, because the government really never comes forward to put their own version of events, particularly when I would say it's more disappointing when they're the ones that actually requested this panel discussion in the first place. But responding to your question, yes, it's a very easy question to answer, because there's really very little that I can say. And as you very kindly said in your introduction to me, I've been involved with a number of different tribunals and judicial processes to deal with atrocity crimes, and they all have their positive and negative aspects. No judicial process that looks to justice and accountability for past crimes is without criticism. But I think this is probably the one which is more criticised than any other process that I've ever encountered. But in terms of what you could possibly say that is positive, I would really only say two things. I'm a great believer in national tribunals and these processes being dealt with where the crimes were committed. I spent a number of years working in Bosnia, setting up a national court with international assistance that would look to address those crimes in Bosnia. And it was a very successful process. So I think there is certainly something to say when a government is given the opportunity to deal with the matter themselves, even with international assistance. So I think the first point is that, yes, there should be a system of justice and accountability, and ideally the government should be given the opportunity to do that themselves. And they have been given that opportunity, and I regrettably have to say they have failed woefully in doing that, but trying to keep as positive as I can. The other point is that I completely agree that I don't think it matters how long we wait. There should be a system, whether it's 5 years or 40 years. I think the fact that 43 years have passed is not a reason not to establish a process. It is incredibly difficult to establish such a process in Bangladesh, where everything is so polarized, and everything revolves back to the 1971 War of Liberation. It's very clear that the country has not moved very far since 1971 in terms of dealing with this process. And one of the points that Steve mentioned, when you're looking at what actually happened in 1973, the process was started in 1973. It was much more of a military court process. It was aimed to put on trial 195 Pakistani prisoners of war, those determined to be those most responsible for the atrocities, from committing the atrocities on one side, from the Pakistani side. And they were put on trial, and they were repatriated back to Pakistan on the basis that Pakistan would put them on trial, which they never did. And so Pakistan has a lot to answer for in this regard as well. Mm-hmm. But the reason why they were repatriated was because there was a general amnesty, and it was recognized that in the interest of peace and stability that Bangladesh should forgive and forget. And these were the words of Sheikh Mujibur Rahman. And so what you have is much more of a focus on reconciliation than accountability, which I think you can't really have one without the other. There had to have been a system of accountability before there could even be a discussion of reconciliation. So what we're looking at is that the process started, it was then stopped, and then for 40 years the people of Bangladesh sat and waited, and regrettably the response that we have is the one that we have now.
Right. We didn't mention this at the outset, but it's worth keeping in mind that on the kind of positive side, just to add to what you were saying, Toby, in 1971, when these atrocities happened, there was no International Criminal Court, of course. The idea had been floated, had been discussed from the Nuremberg trials in 1946 or 7 forward, but there were forces in the world, including the Cold War, and suspicions that made the idea of a permanent International Criminal Court not workable. So in 1971, when these events happened, you need to give some credit to the government for enacting the law in 1973. That's a good thing. The bad thing is that nothing happened until 2009. The International Criminal Court, which was created in 1998 in Rome, became operational in 2002, but the jurisdiction of the International Criminal Court is limited to events and situations that happened after the creation of the ICC. So if anyone is wondering why didn't the ICC step in and take these cases, because it cannot. Under its mandate, under the Rome Statute, the ICC cannot touch a case like this. So that's just for background purposes. But now I'm going to give each of our two speakers a chance to talk about the bad. What are the concerns about what's been happening with this tribunal from 2009 to now? What do you find most troublesome, and why? Why have these things happened in your point of view, Stephen?
Well, first of all, understand we wanted very much to engage, and we're willing to come to the country and have been there 4 times, and are still willing to do that. I did, by the way, have a call from the Bangladesh ambassador this morning, who asked for a meeting. I said, well, maybe at today's session, and they came back and said, no, he wasn't available then. But I'll speak with him in the next day or so, and continue to press issues that we think are important. And in doing that, I always want to emphasize that we're not antagonistic to the government or to anyone involved in this process, but we think that a process that follows international standards, particularly those that are in the international covenants that Bangladesh itself has adopted, and that has a fair and just process, not that everyone will completely like. We know even in good trials, family members and associates are unhappy about convictions, or other people may be unhappy about acquittals. There'll always be objections to those kinds of things, but to the extent that this is done right, then it can help a society heal. And I know in these unfortunate situations where people talk about crimes that say occurred in 1915, like in Armenia, there were no international trials, no processes, and you wish there had been, that some of these issues had been resolved in a judicial process. And so having a judicial process can help resolve later political things where people feel that they were unjustly treated, and that can justify them visiting, sort of retribution on the children or grandchildren or great-grandchildren of the people involved in the crime. To truly, honor the victims it's important to have a process that will be something that people of good faith on all sides can support. Now, in terms of the approach that we took, we started with this challenging aspect that the statute was put in 1973. It didn't reflect sort of modern developments in international law. It was frankly the Nuremberg statute with a few changes. Now, of course, it's important to note that you can't come along in 2009 and say, okay, we're going to pass a statute for crimes that happened in 1971, because that would violate the rule that you shouldn't pass the crime, as we call it in America, ex post facto law. But international law, and particularly the International Covenant on Civil and Political Rights, says you can retroactively adopt a statute in this area, provided it reflects the international law that was in effect at the time. And so it is possible to prosecute crimes against humanity. It is possible to prosecute genocide. It is possible to prosecute war crimes. But you have to be very careful that you're looking to the law of 1971 and to Nuremberg and the cases and to the developments that occurred and the commentaries and everything that occurred in the 50s and 60s and 70s in order to do that. And we urged them on the substantive law that there were ways that they could, if they couldn't amend the statute, they could come along and provide practice directions or rule amendments that would sort of lay out what the elements of these crimes are, so that people would know definitely what needed to be proved and what didn't need to be proved. That was one of my first suggestions, and there was a great reluctance to do that. Now, to be frank, over time, not in the charge framing decisions where I think it would have been best, so people would have known what needed to be proved and what, if it weren't proved, would lead to a not guilty verdict. Eventually, we have seen, if you look at the case, at the decisions, and I know Toby can criticize them even then, but there has been greater recognition of international law and development. So from a legal standpoint, some of these decisions, I think, have gotten stronger in terms of the legal analysis, and I think that's very positive. But beyond that, there are the other questions about the rights of the accused, and one of the unfortunate aspects, I know, and this happens in every one of atrocity crime situations when they're great horrors, is that those that are involved or the survivors of these tend to view the people who committed these crimes as automatically guilty. And even anyone that goes in and represents them is, how can you be sitting there at the counsel table with these horrible criminals? And somehow there's this attitude that because the crimes are so horrible, we should somehow make it more difficult for these people to be represented. And sitting here with the ABA is, of course, idea is everyone's entitled to advocacy within the bounds of the law, zealously representing the rights of persons that are charged. And just because someone is charged doesn't mean they're guilty. And that's a crucial aspect of, but that's a general principle. But more specifically, in the International Covenant on Civil and Political Rights, and I invite people to look at it. I mean, it's the major international human rights convention. There's long provisions about the rights of the accused and the right to be represented by the consul, and the right of silence, and the right for your consul to be appointed if you're indigent, and the right of appeal, the right to have time and facilities to prepare. And understand, under Bangladesh law, a lot of these rights exist in their courts, in their ordinary courts. If you're charged with murdering 10 people on the street today, there's a long tradition of your rights being honored. But in this 1973 law, they threw out all the rights that applied otherwise. And so the approach that I took was, well, let's bring the rights back in, because after all, you've adopted the International Covenant of Civil and Political Rights, and let's incorporate these rights into this code of procedure. And to some extent, I will note that there are some of them that they then did adopt, but there are others that were not adopted. And then in actual practice, it has been difficult for people to enforce these rights. I mean, Toby will talk about one of the challenges as one follows the trials is certainly, and it's in the International Covenant, that the accused shall have the same right as the prosecutor to call witnesses and to bring them to court and to compel their attendance, and this follows in all procedures. And one of the things that famously happened in the cases there is there were some of the witnesses that the prosecution were calling that didn't appear. And of course, it was something else that we were concerned about is witness protection, because there was a potential of intimidation on all sides. And just because a witness withdraws doesn't mean that witness is a liar. They may be intimidated. But the defense then sought to compel those witnesses, because they had information that those people perhaps had recanted and indeed were going to testify truthfully about what happened, to come into court. And they faced enormous obstacles and were essentially prohibited from calling those individuals in. And when they got a volunteer to come in, that person disappeared from outside the courthouse and was dropped over in India, et cetera, and wasn't available to them. And so it's in practice, you've got these the deprivation of the rights that would otherwise apply in an ordinary case in Bangladesh that has, I think, given us the greatest pause. Now, after we were engaged in making a series of recommendations, and my 10-page letter is in the public sphere, frankly, the government, I think, put it out there, and so you can see all of the specific recommendations, and I can go into them. But one of the other things we did is saying whatever's in the rules, in practice you can do better. You can find in the law and the procedures guidance. You don't necessarily have to have it in the rules. You can have judge-made decisions, and certainly to the extent you've got it in the rules, you've got to follow the rules. So we very much wanted to see the trials monitored, and we supported a program through the East-West Center and the Berkeley War Crimes Center, which you will find their site at Bangladesh trialobserver.org, one long word, and you can go on and get reports about what's happening in court on a daily basis, and you can read about these challenges, and we're hoping by doing that to encourage the observance of these rights.
Hold your thought for just a second, Steve. But a thought occurred to me when you were talking about the omission in the 1973 Act of these fundamental assurances of fairness and representation and so on. Those of you in the room who are familiar with the Nuremberg trial will know that in the charter, the London Charter that led to the creation of the Nuremberg Tribunal, of the four powers, Churchill and Stalin Churchill took the view that why are we wasting time with trials at all? These people are heinous criminals. Let's just put them to death, period. So the point of view that we see in the 1973 Act harkens back to even Churchill. Stalin's viewpoint was, well, let's have trials, but just to determine how quickly we can put them to death, essentially. You know, that kind of a trial. Again, so it doesn't excuse what happened in 1973, but that mentality after atrocities have happened, especially if you're in country and you have seen it, you've seen family members, you've seen innocent people, journalists, anyone who could harm the regime denied these rights, you can see how it might happen, you see. One other point, Steve mentioned the representation and the assumption of guilt. Well, in most civilized countries, including the U.S., there's a presumption of innocence, even when someone looks to be as guilty as sin. And this harkens back to John Adams in the United States when he volunteered to represent the British soldiers who had massacred American colonists. And he suffered, Adams did. He became president of the United States not long after. But at the time, he was shunned by fellow colonists and others. But he set the tone for the United States, and that is that even the guiltiest person or the guiltiest appearing person is entitled to representation in a fair trial. And those of you who know what the result of those trials is that 3 or 4 of those British soldiers were acquitted, even though they looked like they were guilty of sin. And a similar thing happened at Nuremberg. There were some acquittals at Nuremberg. So the insecurity of any government at a time of atrocities has to be viewed with a backward-looking lens, but understanding why they might have taken this approach, not excusing it because it's not the civilized approach, of course, but just by way of putting everything on the table here. But Toby, give us in brief fashion your iteration of the bad. What has this court done that is really unacceptable?
Well, it's very difficult to put it into 30 minutes or even 5 minutes for how bad things are, but just focusing on just a couple of the points that you've both mentioned. So when Stephen was talking about the 1973 Act and how the fundamental rights of the accused were removed, and I completely take your point that in the immediate aftermath of conflict, there is a sense of pursuing victor's justice, and actually in all of our final trial briefs and all of our appeal briefs, we quote Justice Jackson when he said that, and I won't quote it verbatim because I'll get it wrong, but basically, you know, if you're determined to execute a man in any event, there's no occasion for a trial, and so we have extensively argued that point. But it's important to note that it was a first constitutional amendment that withdrew the fundamental rights, and it's not just the rights that we would recognise that contained in the Constitution or contained in the international treaties. So all of those fundamental rights that are contained that go to fair trial have been removed, and it actually explicitly states for those charged under the International Crimes Tribunals Act. So specifically in relation to these cases. But not only that, the legislation prohibits any challenge to the legislation itself, to the jurisdiction of the tribunal, and to the appointment of any particular judge. So, taking a very extreme example, we are prevented from challenging and seeking the removal of a judge on any ground. And we did have occasion to request the recusal of one of the judges, because, and this was really the first controversy, and it's important to note that there have been many controversies over the last 3 years, and each one seems to overshadow the last. So the first one was that we became aware that the chairman of the tribunal was previously a member of an investigative commission that had investigated these very cases several years previously. And so it was our opinion that he couldn't possibly sit as a judge. And so we sought his recusal. That was denied. And the other judges left it to the, as they put, the good conscience of the judge in question. Regrettably, the good judge didn't have that much conscience. So he continued to sit. And then this was then followed sometime later by a release of discussions, Skype conversations and emails that the judge had had with third parties about how these cases were prepared and how they had discussions with members of the government and how they discussed it with the prosecution. And so that judge was then forced to resign as a result of that. And then another judge appointed. But there have been numerous times where we've felt it necessary to seek the removal of a judge to ensure that the trial process is not only fair, but it has the appearance of fairness. And unfortunately, we've been stopped at every opportunity. Stephen also spoke about the issue with where some of the witnesses were refusing to come forward, or at least that's what the prosecution had set out. And so what they tried to do, and succeeded regrettably, was to have all of their evidence heard by way of a statement alone. We had no opportunity to challenge that evidence. And one of our central allegations was that the chief investigator who had taken these statements had misled the court and had fabricated many of these statements. So we had no opportunity to challenge that. And regrettably, one of the witnesses in question, and Stephen alluded to this slightly, but I'll elaborate because it is one of the most fundamental issues that we've faced. There was a particular witness who had given evidence that his brother was killed by, in his statement, by the defendant. And this was really the only evidence to support that charge. Now, this witness had allegedly disappeared and was no longer available to the prosecution. And so his statement was accepted by the court. And so when we were approaching the end of the trial, and it's also important to note that in each and every case, we have been prevented from presenting the full extent of our defense case. So once we've called 4 or 5 witnesses, the tribunal has taken steps to, as they call, to guillotine the defense case, because we've taken too long to bring our witnesses. And so the case had been closed arbitrarily in our view, and we had made contact with this witness, we had located him, and he was prepared to give a statement for the defense, saying, 1, the defendant did not kill my brother, and 2, I was forced to say so by the investigators. And so we brought him to the tribunal, and he was abducted by members of the security forces, police. He was, by his own words, held and interrogated for weeks on end. And then he was, sorry, I start to lose my voice now. And he was then found in India about 3 months later, having been tortured.
Take a sip.
Sorry.
Water.
No, I think I gave. And so we'd raised this repeatedly, and there's been no investigation at all. And this man now stands to his appeal is ongoing, and he's likely to be the next execution. So, there are numerous instances of attempts by the government, by judicial and prosecutorial misconduct. And so to go through all of these would take hours.
Yeah, I think you've given us a flavor of this, and there are many, many others like the ones you mentioned, of the terrible problems of fairness, denial of procedure. But if someone were sitting in this chair, we might hear the justification that I've seen in writing, that the decision was made either expressly or, as things happened, that yes, you might be sacrificing some procedural fairness, but it's in the name of achieving substantive justice. What's your reaction to that justification, if you will?
Well, that was actually used recently in an article, I think, by a professor from Australia of Bangladeshi origin, where he referred to defence nitpicking, and these matters, as terrible as they are acceptable when you look at the notion of substantive justice. The problem that you face is, and this is an argument that we've repeatedly raised over the last 3 years, is that if you arbitrarily try and convict and execute a number of individuals, there is of course going to be a response to that. It shows that the process is stage managed, as we believe it is from the very beginning to the very end, and it serves no lasting purpose whatsoever. And you can compare this to other systems where they've attempted to bring an end to impunity and put those deemed most responsible on trial. And in order to go to the next stage of looking at a system of reconciliation, long-term reconciliation, you need to ensure that the process stands up to scrutiny. And regrettably, this process does not stand up to any scrutiny at all. And just the final point that I'd make, I represent one side, and so what I say has been repeatedly criticised by the government, to the extent that I was detained at the airport and thrown out of the country and told never to come back. But it's not just my words. The ambassador has been very kind to the government when he says that his recommendations were accepted in some part. I mean, the truth of the matter is they were not at all, and those that have been accepted are never practically applied. So you have the recommendations of the US government, you have the United Nations, you have nearly every reputable human rights organisation has criticised this process, and you can even go back as far as 1972 when the International Commission of Jurists recommended that this should be a process under international supervision. And really that's where we are now, is that this is a process that cannot be allowed to continue in this way, and it has to be under UN supervision.
I have, it's Toby's turn in terms of the questions, even though I've been peppering him a little bit, but let's not lose the point that you made, that in a very casual way. You were ordered out of the country in 2011. You haven't been back to Bangladesh since then, and you're not welcome to go back.
That's right.
And because of your expressing your views about the fairness of the tribunal. But here's my two-part question, and again, a brief answer, Toby. You've practiced before all these tribunals. You've read, you know, and both of you are familiar that there were growing pains. The International Criminal Tribunal for Yugoslavia and Rwanda and Lebanon and Cambodia, they all went through kind of rough periods, obstacles to overcome, growing pains. Is that part of the problem here, or is it a matter of degree and magnitude of the kinds of missteps that this court has taken compared to the other tribunals? And then I'd like you, both of you, to answer, can it be overcome? What they've done, can it be overcome so that they do become a reputable, respected, fair tribunal. So that's the two part.
Yep.
And I'd like both of you to react to those two parts.
Well, I think the first part is primarily, of course, every institution has its growing pains, and there were requests at the outset to invite the ambassador's recommendations, but also to solicit the advice of the United Nations. But it's very much, I'm going to ask you a question, and I'd like you to respond with the answer that I'm going to give you. And if you don't give me the answer, I'm not going to ask you any more questions. So what they've effectively done is they've sought the assistance of the international community. They don't like the answer they've been given, and so then they've ignored it. They have closed the door to assistance from every source, whether it's from the US, the United Kingdom, the United Nations, and I'll give you one example. The International Center for Transitional Justice, based in New York, had initiated a process where they would give assistance to judges and prosecutors to get them up to a certain level. And so they arranged a study trip for the judges to go to The Hague to observe the ICC, to observe the Lebanon Tribunal, Yugoslav Tribunal, and give them an opportunity to answer or ask questions on how to deal with these very difficult cases, and to ensure that the quality of the evidence that they were hearing was of a standard that convictions could be brought upon. Well, because of the manner in which the tribunal then carried on, the ICTJ then cut its program and has provided no assistance to the tribunal as a result of that, which is regrettable, because most institutions now, noting how these trials have been conducted, have effectively washed their hands with them. Now, if they're European-based organizations, a lot of that is based on the death penalty, and it is deeply regrettable. We've tried to convince all of these organizations, the United Nations included, you cannot wash your hands with this process. You have to insist and ensure that an appropriate standard of justice is applied. Just washing your hands and walking away is no answer, because what you're going to see is a number of these individuals summarily convicted and executed. And the important point in that regard, and it's become more important recently, we are talking about the almost entire leadership of a conservative Islamist political party. So executing those individuals, of course, is going to see a response. And we have seen a response to that. I mean, even there have been statements of concern by a host of Muslim countries. There have been Islamic organizations have raised their concern. And even as we've been warning for a very long time, that Al-Qaeda has also issued a statement in that regard as well, expressing concern as to how Islamic leaders are being treated in Bangladesh. So that is one of the issues. It's not just growing pains, that the government has been given every opportunity to address these concerns, and they have failed to do so because of a number of different reasons, primarily because they want to do it this way, and they will not be told.
Get to part two of my question then. What's it going to take for them to turn it around and become respectable and successful in doing what they should have been doing?
Well, I think there are two things that can be done. First of all, the whole trial process has to be stopped now, and there has to be a complete review of
Stop the trial process right now?
Yep, it has to be stopped now. There has to be a complete review of the entire process. There have to be judges and prosecutors properly selected based on their expertise, not based on party affiliation, and it needs to come under international supervision. It is absolutely essential that international judges and prosecutors assist in this process, because Bangladesh has shown that it is neither willing nor capable of doing it without that assistance. And then the second point is that, going back to the point I made at the beginning, that it is, in my view, better to hold trials in the areas where the crimes were committed. But you have to really look at whether holding these trials in Bangladesh will impact upon regional stability, and I believe it will. If they continue to do this, it will impact upon regional stability. India and Pakistan both have very much a lot to lose in relation to this process. And already in December, when the first defendant was executed, there was a very strong response from the Pakistan National Assembly condemning what had happened. So there is a regional component. So the trials should be moved out of Bangladesh to ensure that justice is applied.
Okay. Steve, take that two-part question, and then we're going to get to one more question from me, and then I want to leave 15 minutes for audience questions. So.
Well, first of all, I think if we go back to the beginning of your question, you were talking about, obviously, in these international courts, you do have growing pains, you have challenges, and the approach that we try to take is to look at what other courts have done, to overcome them, to learn lessons and hard learned lessons at some of these courts, and there are approaches to this kind of crime. We all know that it's challenging to prove what happened 42 years ago, when many eyewitnesses have passed along, and when memories fade, and when people may gain a kind of collective attitude about what happened, and it's not based upon what they themselves saw or witnessed. But there are ways to overcome that, and we've spent some time with international organizations urging them to look at these things. And I know when I was there meeting with the prosecution, I would sit and say, now look, this is how we were able to prove these crimes a decade after the fact. And I must say the initial reaction that I had was, we don't need any of that. These guys are guilty. 3 million people were killed. 200,000 women were raped. That's what the leader of the country said at the time. And I said, well, that can be true, and presumably you can prove that quite easily, but how do you prove these people are responsible? And that there are ways to do that if you can show a command relationship, if you can show some kind of joint enterprise in which one person was doing this and another person was doing that with a common purpose, or if you can show that someone aided this particular act with knowledge, et cetera. And you can prove these things. And classic attorneys might say, well, but can you, are there witnesses? Well, can you use documents, et cetera? You can potentially use documents. Rules against hearsay haven't been applied in international courts as long as the substantial justice is done. And so there are ways to approach these issues and to overcome them, but always looking for the substantial justice of the process. And as that went forward, I think, to be frank, the concern that we had was that, to a large extent, the evidence didn't come forward, and it was very difficult for them to tie particular individuals to these crimes. And if you read the judgments, there's some leaps that are made. That further investigation might have filled those gaps, and that international assistance and could have helped them. And of course, if you can't close that leap, if you can't connect that individual, then you don't have a case. You need to go elsewhere. And so, there was. The frustration was this attitude that these people have committed horrible crimes, therefore they must be convicted no matter what, and that's the kind of attitude that concerned us, and said that at the end of the day, if you're going to respect the victims, you need to do it differently. Now, what can be done now? And obviously, when I was last out there and no one had yet been executed, and cases were then just reaching the appellate court, the criminal division of the Supreme Court, it was, I think, easier to talk about things that might be done to improve the process that's there. And obviously, given what's happened to date, it's difficult, I think, to fix some things after the fact. On the other hand, if one were to approach this, Toby talks about international supervision, I don't envision that the international community is going to jump in there and say, we want to take over these trials. This is not a situation, and we know the challenge of dealing with a situation like Syria today and getting a consensus about a referral or some kind of international court mechanism. Dealing with a situation in 1971 would be very difficult for the international community to come in and take it over. On the other hand, if the government itself were to reach out to the international community, suggest the kind of things that they did in Bosnia. The Bosnian state court is not an international court, but it had international judges. It had international prosecutors. They were nominated by international groups, but effectively then appointed by a broad-based national judicial and prosecution council, et cetera. So you could develop that kind of structure and bring in people from the international level to join with Bangladesh lawyers to help ensure the fairness and independence of the process. And that process could also include, as all legal processes do, opportunities for people to petition for review if a particular proceeding didn't, fundamentally violated the rights of the accused. So it's not impossible, even at this late date, to think of that kind of approach. Of course, there'd have to be a will on the part of the international community to get involved. As Toby points out, the death penalty issue is there, and that does cause a problem with the involvement of the United Nations and with the European Union. It doesn't necessarily we have in many states the death penalty in the United States. We certainly insist that if you have a court that has the death penalty, that it only be reserved for cases in which there's been an absolute and total observance of the highest standards of due process and the strongest proof at the highest standard before you would execute that kind of punishment, and it would have to reflect a truly heinous crime and a major involvement. But many countries, I think, would be reluctant to come in if that were still on the table. And as I recommended back in 2011 in my letter, I said it would be better in terms of this process if the death penalty were off the table, and if the maximum sentence were a life sentence, and then the problem that I think a lot of people had in Bangladesh, because of the political polarization, was, well, if we don't have a death sentence, then if there's a political change in the future, then everyone will be freed after only a year or two in jail, et cetera. And so we, a little like we had in America, and if jurors thought that prisoners would be freed, then many would vote for the death penalty. If they realized that the alternative was a true life sentence, then many jurors end up saying, no, we'll do that instead. So people had that kind of attitude. Well, to the extent that you develop a process that's independent and impartial, and have an understanding by people on all political sides that whatever the results are should be honored and observed, and that a sentence of life means life, then I think that you can eliminate one of the strongest arguments for a death penalty in it. But I think if you're really going to do this process now, you'd really need to take that off the table and have international participation, not because there aren't very good people in Bangladesh, but because of the nature of the process that's gone on to date, that kind of inclusion, I think, would be essential to showing independence and impartiality.
Okay. Well, I have one more question, but I think what I'll do is hold it and see what questions you have, and if there's time, I'll ask the question I have. If not, I won't. So starting with here, my vision is here. We'll jump from one side of the room to the other. You're first. Brief question. Don't make statements. Question, and then brief answer. Yeah.
A few questions.
Out.
A few.
I'll start with a very simple one.
Yes.
Which is, thank you for organizing this panel discussion. I came in a little late, so my first question is, I wanted to hear two sides of the story, and I see there is a representation of the Defense Council, and I don't see the thing that we're talking about, International Crimes Tribunal Bangladesh. There is any representation of International Crimes Tribunal Bangladesh. I don't see any representation of the victims. I don't see any representation of any Bangladeshi people. So my first question is actually to you, why is this such a one-sided panel discussion?
Well, how late were you coming in?
Like 15 minutes late.
Because you would have heard me say that the Bangladesh government asked the American Bar Association to hold this neutral forum. We agreed to do it. We invited distinguished guests. And 2 weeks ago, the Bangladesh government said they weren't going to send anybody. And so we've been trying our best to make it a balanced presentation here with my questions and comments. But that's the answer to your question. Now let's move around, and if there's time, we'll come back to some of your other questions. This side, yes.
Hi, my name is Roshani, and I work at the Public International Law and Policy Group. And I have a question. So we look back years from now at the Bangladesh Tribunal, and I'm wondering what your opinion of the ICT will be in the spectrum of international tribunals, be international, hybrid, or domestic. Do you think that this is going to be a case of, the flaws of a purely domestic tribunal trying international trusts?
Well, I mean, first of all, we strongly, the U.S. government and it's a principle of the ICC, believe in complementarity, and we would prefer to have justice at the national level. And we have examples. Certainly, if you go to Latin America today, you'll see cases that arose out of periods of what they often call the dirty war in Argentina, or when people of the left or the right were mistreated, tortured, killed, etc. And cases are being tried at the national level, and judgments are being reached that are being recognized and respected across those countries, etc. So it is possible, and many of those crimes, by the way, occurred in the 70s and 80s that are being prosecuted. So it is possible for people to do it. I think here we have an example that unless we see some changes in the approach, will be viewed as a national tribunal prosecuting international crimes, and the deficiencies of that process will be much more prominent here than they are in some other experiences.
Okay.
Sorry, could I just very
Yes, sure.
quickly? I think when we first started looking at this process, this was potentially going to set an example of how the national jurisdiction could actually be an important component of international criminal justice, and it could be looked upon as what to do in the future. Regrettably, I think my position would be this is precisely what never to do again.
Okay, way in the back. Brief question, brief answer. Yeah.
Can you hear me without the mic?
Yes, we can hear you, yes.
This is really a truly factual question. What's the magnitude of this effort? How many defendants are there going to end up being? Who are they? I know that it seems to have started at the top of the food chain. How low on the food chain of potential offenders is it going? How many indictments are there? I'd just like to get a little bit of background. I'm sorry, it may be that I'm the only one ignorant of those details in the room.
Toby, and
Regrettably, I don't think that you are the only one ignorant of this, because most people really do not see what's going on in Bangladesh. So it hasn't really been something which has been openly discussed. In terms of whether they're looking at only those at the top of the food chain, as you say, it's important to note that nobody from the Pakistani military has been or will be put on trial. Nobody from the Indian side, if they were alleged to have committed crimes, would be put on trial. And it's only those who have allegedly collaborated with the Pakistani military that are on trial. You also have a presidential order that states that nobody that fought for liberation can be put on trial. So that's another criticism of the process. In terms of how many people, we have one person who's been executed, who was executed on the 12th of December. There was another defendant who died in custody just over a week ago. Ironically, he was previously prosecuted in 1973, convicted, sentenced to life imprisonment, and then, as part of an amnesty, released and has just been put on trial again. There is approximately 10 other cases either completed, awaiting appeal, or in the process. In terms of who they are predominantly members of Jamaat-e-Islami, the Islamist political party. There are one leading member of the Bangladesh Nationalist Party, but they're all those that may have opposed independence or liberation, and who are in some form predominantly, but not exclusively, members of opposition political parties.
And in that regard, I should say that we're talking obviously about people that may have only been 20 years old or something at the time of these crimes. So we're not necessarily, though there's one very aged accused who was more prominent in 1971. These are generally not people who would have been high up in culpability now, but by the same token, some of the Auschwitz guards and others that are being prosecuted today for crimes in the 1940s may not be necessarily prominent. Generally, the cases involve allegations that these militias of Bengali students, et cetera, that organized themselves to support the Pakistani side in the liberation war, in other words, opposed liberation, and formed themselves as militias that had names like Al-Badr or Razakar, et cetera, that these militias were engaged in attacking Hindus, attacking secular Bengalis, et cetera. And indeed, there were these crimes committed by organizations like that. The crucial question then is what role these individuals that are charged today played in those events, et cetera, and that's the proof that would really be needed to convict them, and that's been, as I note, and if you read the trial record, the evidence has not been strong, and sometimes the connections between them and these killing units don't appear readily in the evidence.
So we have about 5 minutes left, and it's this side of the room's turn. Excuse me. Yeah.
I wanted to know, I'm Shiva from Bangladesh Service Voice of America. Did the Bangladesh government give any reason why they were not sending representatives?
They said they were unavailable, essentially. Kip Hale dealt with it directly. Kip, what more can you add to what I said?
All they said was that the ambassador at the time was ill with some condition, and he was a replacement of a replacement. And then there was an effort to secure another replacement, and was unable to do so.
Yep. Okay, that was a short question. This side, I'm trying to go back and forth even on this side, and so I think this question, yes.
Yes, if the trials were to stop, would the inclusion of victims as individual civil parties like they did in the ECC, and I think in Sierra Leone, would that hinder the equality of arms, or do you think will benefit it?
I mean, I don't know what the position is ordinarily under the laws of Bangladesh, whether injured parties, victims can participate in the proceedings. But I think any system which is aimed at reviewing the process and making a determination of what a future process should look like should involve civil society and victims groups. I don't think that there's anything wrong with that in terms of their voice being heard on what type of process should be established.
No, I mean them actually being party representatives like the Cambodia tribunal, where they had their own separate lawyer and they were able to question the defendant as well, and their own evidence and whatever.
Again, I don't know if that's permitted under Bangladeshi criminal procedure in normal proceedings. It is something that some of the victims' associations have raised in the past, but it's not something that's really been considered.
And understand here, we're generally following a sort of a common law legal system where the prosecutor comes in and presents the evidence. Now, obviously, those of us that are involved in that kind of process, as prosecutors, believe ourselves very much then the representative of the victims, and the need to develop that relationship and that contact is what we try to do. Obviously in the ICC, we now have victim representation in this sort of global court. But fundamentally here we're talking about trying to have a process that fits Bangladeshi law and traditions, but the best of those traditions and the greatest observance of rights, particularly given the historic importance of these cases.
Okay. This side, we have time for maybe another 2 or 3 quick questions. Anyone else on this side? Okay. Yes.
My question to Mr. Rep, I think in your last public appearance in Europe, you mentioned that during the appeals process, some of the shortcomings in the trial of ICT will be taken care of. But unfortunately, we have seen one life sentence turned into a death sentence, which was horribly wrong. So what is the responsibility of the international community now to stop this injustice in the name of justice?
Well, I understand it's important for the international community when it comes to international human rights guarantees to speak out and to express our views and to try to get those standards adhered to. You're referring obviously to the Mola case where he was sentenced to life at trial. The law did not allow a prosecution appeal. the law under popular pressure then was changed to allow a prosecution appeal, and on that appeal, the conviction was essentially upheld, and the sentence turned into a death sentence. At the time, I spoke to that issue and said that it was very important that there be a review of a decision like that. Now, in the end, there was a period of time when the idea of even having it reviewed by the Supreme Court was opposed. In the end, it was reviewed by the court itself, the same court that had rendered that decision. And I think most of us would say, in terms of the right of appeal doesn't mean going back to the same court that decided it. It needs to be to another court. So there was a serious concern under international human rights law about the execution taking place under those circumstances, and we made that clear, and certainly urged the government not to go ahead, and they did. Since then, we haven't had other executions. We hope that now, of course, we're not dealing now generally with situations where there was no death sentence at the trial. There are many cases in which there are death sentences at the trial, and so there will be appeal. But our position remains the same in terms of looking at the review of a death sentence by a court on appeal, and that is that for the execution of this kind of supreme punishment, which is permitted under international civil right, under the International Covenant on Civil and Political Rights, death sentence is allowed, but these should be reserved for cases in which the evidence is extremely strong and in which all of the procedural guarantees have been observed. And we think that kind of review would result in a situation where death sentences may be set aside.
Well, we're out of time, and I want to bring it to a close. I have to bring it to a close, but I do want to make a couple of very quick observations, final observations. Ambassador Rapp came to China when I was there last fall. I teach a course in China called International Criminal Justice. It starts with the Nuremberg trials and comes all the way forward to present day. If you haven't taken a course on international criminal law or international criminal justice, I suggest that you do so, because this subject is of critical importance to the world in terms of dealing with atrocities that never seem to end. We thought that after World War II and the cry of no more, never again, but it's happening again and again and again. The International Criminal Court is the only permanent tribunal. The other courts, as those of you are aware, are being phased out. The Yugoslav Tribunal, the Rwanda Tribunal, they're being transitioned so that by 2016 or 2017, the only international court will be the ICC. We've had today discussion of essentially a fundamental precept of the Rome Statute that created the ICC is complementarity. Both of our speakers have referred to it. In a nutshell, complementarity means that in Rome, in 1998, when 160 nations came together and met for 2 weeks and created the Rome Statute, the fundamental premise, one would argue, of the Rome Statute is the assurance that the International Criminal Court, once it started operating, would respect the right of sovereign nations to try their own cases. And so complementarity means that the ICC is a court of last resort, not first resort. The first resort is the national courts. Today we've heard of that complementarity principle, which doesn't really apply because everything that happened here in Bangladesh predates the existence of the ICC. And as we mentioned earlier, the ICC, no tribunal especially, can take over this case. But it's a lesson to us. It's a lesson that even under complementarity, when we have the ICC, if it had jurisdiction of this case, would still have looked to Bangladesh to try this case unless Bangladesh was unwilling or unable genuinely to do justice in this case. I think we've seen that justice has not been done, and there's a threat that that will continue unless something happens. So my last comment, and a quick question, a yes or no, as using my prosecutorial skills. for each of our speakers, does the Bangladesh experience argue that the international legal community should do more, should redouble its efforts to strengthen the International Criminal Court so that it is available, even as a last resort, to step in a situation like this when a national court is unable or unwilling to do it? And so I think your answer is going to be yes, but I might be surprised.
You know, and obviously important to have strong international courts to deal with situations where you can't have justice at the national level. There's no question about that. But I do think that the imperative, and particularly obviously in dealing with a situation in 1971, which cannot, under the Statute of Rome, under any circumstances, be an ICC case. It cannot be. Not even if the Security Council voted 15-0 could you get the ICC involved in a case that occurred in 1971. I think this causes us all to conclude that we need a redoubling of effort to provide assistance and to encourage and to the extent we can do it, to respectfully provide pressure to have countries proceed with these cases, hold people to account who are responsible for serious atrocities, but to do it in a process that meets fair standards and will stand the test of time.
Good. Toby, do you want to add?
Yeah, I think my answer to that would be yes, the ICC has a duty over its members. But I think the question also is, should a country be entitled to remain a member when it is allowed to continue trials in this fashion and relying on the fact that it falls outside the jurisdiction of the ICC? And I think the ICC, particularly the Assembly of State Parties, has a duty to ensure that its members are not flouting its obligations under international law.
That's a very interesting premise with which I think I would disagree, but we'll discuss offline. But so we're at an end. The time has gone by very quickly. I want to ask you to join me in thanking our speakers who've done a wonderful job.